Your phone is on your desk. You are in the middle of a meeting. Your coworker walks in and says, "There is someone on the main line asking for you. They say it is urgent." You step out. You pick up. And a voice says, "This is ABC Collections. We are calling regarding an outstanding debt of $4,200. Your face goes red. Your hands go cold. You can hear your coworker still standing nearby. Your manager just walked past the door. And in that moment of complete humiliation, you say whatever it takes to end that call as fast as possible. Maybe you promise to pay. Maybe you give them your cell number. Maybe you just hang up shaking. That moment, that exact feeling of being cornered at your workplace, is not an accident. It is a calculated tactic. Debt collectors are trained to create maximum discomfort at the most inconvenient moments of your day. Because a person who is embarrassed, rushed, and professionally vulnerable will say things they would never say from the privacy of their own home. And what you say in that moment can legally be used against you. But here is what they are counting on you never finding out. That call, in most circumstances, is a federal violation, and every single call they make to your workplace after you tell them to stop is worth $1,000 in your pocket. Today, I am going to break down exactly what the law says about debt collectors contacting your employer, what your precise legal rights are in 2026, what collectors can and absolutely cannot do, and the exact steps to shut this down permanently, and potentially get paid for every time they cross the line. To understand why this is so serious, you first need to understand how collectors even get your workplace number in the first place. When you originally applied for a credit card, a loan, or even a store financing plan, that application asked for your employer name, your work address, and sometimes your direct work number. That information gets stored in the original creditor's database. When your debt gets sold to a collection agency, that entire file transfers with it. Your workplace number is sitting right there in their system before they ever dial it. Beyond original creditor records, collection agencies use something called skip tracing. This is a professional process where collectors use data broker services like LexisNexis, the Equifax Work Number, and other employment verification platforms to locate your current employer, your job title, and your workplace contact information. All of this is completely legal on their end. They can find your employer. What they cannot do is abuse that information. And that is exactly where federal law draws a very clear and very enforceable line. That line is called the Fair Debt Collection Practices Act, the FDCPA, specifically Section 805A(3). And in 2026, this law is still in full federal effect with active enforcement from the Consumer Financial Protection Bureau. Here is exactly what Section 805A(3) states in plain English. A debt collector cannot contact you at your workplace if they know or have reason to believe that your employer prohibits such calls. The moment you tell a collector that your employer does not allow personal calls, that knowledge is established. From that second forward, every single call they make to your workplace is a direct federal violation. Now here is the critical legal distinction that most people miss, and missing it costs them everything. The very first call a collector makes to your workplace is technically in a legal gray area, because they can argue they did not yet know your employer prohibited such calls. That first call is uncomfortable and embarrassing, but fighting it legally is difficult. However, the moment you say those words, "My employer does not permit personal calls," the gray area disappears completely. What comes after that is black and white federal law violation territory. This is why what you say on that first call matters enormously. Let me give you the exact words, right now, that you say the moment a collector reaches you at work. You do not explain yourself. You do not apologize. You do not discuss the debt at all. You say this and only this. I am at work, and I cannot discuss personal matters here. My employer does not permit personal calls at my workplace. You are not to contact me at this number again. Send all future communication in writing to my home mailing address. Then you end the call. No negotiation, no explanation, no back and forth. 4 sentences and you are done. Because the moment those words leave your mouth, the clock starts on their legal obligation to never call your workplace again. Now let's talk about what collectors can and cannot do. Because understanding both sides of this line is what makes you truly protected. What a collector is legally permitted to do. They can make one initial attempt to reach you at work before your employer prohibition is established. They can contact your workplace solely to locate you, meaning they can ask if you work there, but nothing more. They can ask to be transferred to you, but they cannot reveal why they are calling to anyone else. And they can continue collection efforts through other legal channels, like mailing to your home address, even after workplace contact is prohibited. What a collector is absolutely prohibited from doing, and each of these is a separate federal violation. They cannot call your workplace after you have informed them your employer prohibits it. They cannot tell your receptionist, your coworker, your manager, or your HR department that they are calling about a debt. They cannot use language on that workplace call that is threatening, abusive, or obscene. They cannot call repeatedly to your workplace with the intent to harass or embarrass you. They cannot pretend to be someone they are not, a lawyer, a government official, a court officer, when calling your job. And they absolutely cannot tell anyone at your workplace that you owe money. That last one, disclosing your debt to a third party at your employer, is not just an FDCPA violation. It can simultaneously become a defamation claim and an invasion of privacy claim, which opens the door to damages that go far beyond the standard $1,000 statutory amount. Now, let's talk about the real-world consequences of what happens when collectors cross these lines at your workplace. Because the damage is not just emotional. It is measurable, documentable, and legally recoverable. When a collector calls your job, your professional reputation is immediately at risk. Coworkers who overhear learn that you are being pursued by debt collectors. Receptionists who take the message become aware of your financial situation. Managers who notice your distressed reaction begin to form impressions about your reliability and focus. In industries that require financial trustworthiness, banking, accounting, government contracting, security, this kind of exposure can directly affect your employment status. People have lost jobs over collector harassment at the workplace. People have been passed over for promotions. People have had security clearances reviewed and revoked. These are actual damages, beyond embarrassment. And under the FDCPA, they are legally recoverable in court. Here is how the damages calculation actually works. Because most people only know about the $1,000 number and stop there. Under the FDCPA, statutory damages are capped at $1,000 per lawsuit, not per violation. But actual damages have no cap. If a collector's workplace calls resulted in you being fired, your actual damages are your full lost salary, your lost benefits, your lost future earning potential, and documented emotional distress. In cases where collectors disclosed debt information to employers and employees lost their jobs, courts have awarded damages in the tens of thousands of dollars. The $1,000 statutory amount is the floor, not the ceiling. when real harm has occurred. Now, here is your complete step-by-step action plan. In the exact sequence that gives you maximum legal protection and maximum leverage. The moment a collector calls your workplace and the moment that call ends, you sit down and document everything before another minute passes. You write down the exact date, the exact time, the name of the person who called, the company they said they were from, the phone number they called from, whether they called the main company line or your direct extension, whether any coworker or receptionist heard or was involved in the call, and word for word, to the best of your memory, exactly what was said on both sides of that conversation. This documentation is your evidence. Without it, you have a complaint. With it, you have a case. Within 24 hours of that call, you send a written cease contact letter to the collection agency via certified mail with return receipt requested. This letter does not need to be complicated. It needs to say clearly, per FDCPA section 805A 3, you are hereby notified that my employer does not permit personal calls at my workplace. Cease all contact at my place of employment immediately and permanently. All future communication must be sent in writing to the following home address. Sign it. Keep a copy. Send it certified. That green return receipt card that comes back to you is your legal proof that they received the notice. From that date forward, any workplace call is an automatically documented federal violation. Simultaneously, file a complaint with the CFPB at cfpb.gov. This takes less than 15 minutes. Describe exactly what happened. Dates, times, what was said, who was involved. The CFPB is legally required to forward your complaint to the collection company, and that company is legally required to respond within 15 days. Your complaint becomes part of the federal regulatory record against that agency. The CFPB monitors complaint patterns. Companies with repeated violations face escalating regulatory scrutiny and potential enforcement actions that go far beyond your individual case. File a second complaint with your state attorney general's office. Every state has a consumer protection division that handles debt collection complaints. State-level investigations can result in state fines and penalties against collection agencies that federal CFPB action does not always cover. 2 complaints, 2 simultaneous pressure points on a company that violated your rights. If violations continue after your written notice, you now have everything you need to take legal action. In small claims court, which you can navigate without an attorney in most states, you can file for $1,000 in statutory damages per lawsuit, plus any documented actual damages. Filing fees range from $30 to $100 depending on your state. Many collectors settle before a hearing because the cost of defending a case exceeds what they would pay to settle. If your situation involves significant actual damages, job loss, formal discipline, documented emotional distress, a consumer protection attorney is your stronger route. Under the FDCPA, if you win, the collector pays your attorney fees. Your out-of-pocket cost to fight this case is 0. There are 3 mistakes that will significantly weaken your position if you make them. The first is ending the workplace call without saying the specific words about your employer, not permitting personal calls, because without establishing that knowledge in the collector, every subsequent call remains in legal gray area. The second is failing to send a written cease notice, because verbal statements are much harder to prove in court than a certified letter with a documented delivery receipt. The third is waiting too long to file complaints and document violations, Because the FDCPA has a 1-year statute of limitations for filing lawsuits, and evidence becomes harder to reconstruct as time passes. Your workplace is where you build your career, where you maintain your professional reputation, where you earn the income that supports your life. A debt collector using that space as a pressure tactic is not just embarrassing, it is a federal offense with real legal consequences for them and real financial recovery available for you. The law was written specifically because Congress recognized that workplace harassment by collectors could destroy livelihoods, not just credit scores. You now know exactly where the line is. You know exactly what to say. You know exactly what to document. And you know exactly how to make them pay. Literally, for crossing it. Subscribe right now, because next week I am covering what happens when a debt collector threatens to garnish your wages, what is actually legal, what is a complete bluff, and the one document you can file yourself that freezes the entire process before they touch a single dollar of your paycheck.